Welcome to the Minnesota Association of Realtors e-video resource. My name is Chris Galler. This morning we're going to talk about exclusive agreements in a changing real estate marketplace. As market forces continue to shape the real estate industry, with leasing opportunities becoming an option many members have pushed for, your Minnesota Association of Realtors committee and legal staff have been tackling the related issues and encountering a number of established roadblocks. Exclusive agreements have been part of real estate contracts for many years, and the statutes were written and passed into law years before the current market reality was recognized. One significant concern is related to exclusive agreements for representation and whether another real estate broker can contact or draft a separate exclusive agreement for different real estate services. The issue is complicated by the fact that there are three levels of enforcement a broker and agent must face if indeed found a violation. One is a Code of Ethics violation through the Realtor organization, a Department of Commerce action against your license, and the third is a judicial remedy through a civil action where a consumer or broker would sue you. In Minnesota Statutes, Chapter 82.41, the interpretation we are most concerned about is the one that appears to be most logical in reading the current statute. That is, the plain language of the statute currently appears to prohibit entering an exclusive agreement in connection with the property where one already exists. In the statute in red, you'll see it says, in Chapter 82.41, Subdivision 10, Paragraph A, a licensee shall not negotiate knowing that the owner or lessor has executed a written contract granting exclusive representation or assistance in connection with the property. While the Realtor Code of Ethics and perhaps the Minnesota Department of Commerce may allow for this to occur in certain circumstances, unless or until the statute is changed, there will be risk for brokers and agents who try to enter an exclusive agreement related to a property where an exclusive agreement already exists. Further complicating the issue is verbiage in Paragraph B, the language stating a licensee shall not induce a consumer to breach a contract, and Paragraph C, about when and how conversations between licensees and consumers can occur when an exclusive agreement is already in place. The last sentence of Paragraph C requires the licensee to inquire whether an exclusive agreement exists. However, it does not explain if the licensee is asking about an exclusive agreement on the property or for a service. We have a number of concerns. A number of members have expressed their belief that the language is tied to exclusive services provided to the consumers. Others believe the language is fairly explicit, stating the exclusive agreement is tied to the property. In commercial transactions, there are situations where the building owner has an exclusive agreement to sell the property with broker A, while a tenant in the building has a space they are trying to sublease under an exclusive agreement with broker B. In the commercial marketplace, that seems to work all right, even with the existing language. It very well could be that the statute never considered a residential seller having more than one real estate broker representing them. The role of real estate brokers has evolved significantly over the past 30 to 40 years. The concerns of today most likely were never considered during the time legislature put the language in place. That brings us to the Code of Ethics. Much of the confusion comes because of the Realtor Code of Ethics in Article 16, Standard of Practice 16-3. In this language, it does allow realtors from one brokerage to contact the client of another brokerage if they were offering to provide or entering into a contract to provide a different type of real estate service unrelated to the type of service currently being provided. Although code language references services, the code won't apply to a lawsuit or a Department of Commerce action, and the statute is clear on this issue, linking to the property and does not reference services. So what's the problem? Beyond the Code of Ethics, an action can be brought against licensees by either the Department of Commerce or through the judicial system. The Minnesota Association of Realtors has met with the Department of Commerce to discuss the interpretation of exclusive agreements on enforcement actions they'll bring. As we all know, though, regardless of what the Commerce Department says today, they can change their mind. Next year, the department will have a new commissioner, and the new commissioner may view this issue differently based upon the statute language. Even if the department thinks this is allowed, that won't mandate what a judge will allow a second broker to do if a first broker sues them. Nor will it protect members against claims from consumers that they were somehow led into a complicated transaction that produced a result they didn't expect, be it who gets a commission, who advised them during the negotiation, or a range of other things that may come up. This is going to require brokers in the marketplace to take a step back. So that you know our position going forward, the Minnesota Association of Realtors Council has advised us, and the legal hotline will be telling brokers that unless your own attorney advises you differently, it would be prudent to avoid offering services to a party who has already entered an exclusive contract unless this issue is further clarified. This issue will continue to be reviewed and discussed as more brokerages begin to face these considerations. But for now, I believe the most prudent course for the Minnesota Association of Realtors is to advise members that while we are responding to a market demand in providing forms to accommodate leasing transactions, the agency scenarios may create new and evolving dynamics which are best approached cautiously. And that while we advise avoiding potential agency interference issues, they can discuss the issue, meaning you brokers can discuss the issue with your own attorney. We know this is a complicated issue. We'll keep the slides up on the website for you. We will be providing additional information as it becomes available. The Governmental Affairs Committee will be taking up this issue in their October meeting for language changes so that we can appropriately address this issue. We thank you for tuning in today. We hope you have a great week.